The judge in previous President Donald Trump's civil extortion case has rejected an ask from the defense to delay the requirement of the punishments within the case. The litigants had inquired Judge Arthur Engoron to delay the requirement of the punishments by 30 days to permit for a deliberate post-judgment process. "You have got fizzled to clarify, much less legitimize, any premise for a remain," Engoron composed in a mail posted Thursday to the court docket. "I am sure that the reappraising division will secure your reappraising rights." Trump final week was requested to pay a $354.8 million fine, furthermore interest, and was banned from driving any modern York company for a long time. His children Donald Trump Jr. and Eric Trump were fined $4 million each and banished for 2 years. The defense's ask for a delay within the punishments stemmed from a debate approximately the case's judgment range. The court archive that, at the conclusion of a trial, begins the clock for the punishments in a case. Legal counselors for unused York lawyer Letitia James submitted a draft judgment on Tuesday, provoking feedback from Trump's defense attorney Clifford Robert. To deny litigants of the opportunity to yield a proposed counter-judgment would be opposite to principal reasonableness and due handle, Robert composed in a letter to the court Wednesday morning. Afterward that morning, Engoron asked that Robert yield a composed reaction articulating what would make the defense's judgment diverse from the proposed order. Robert replied Wednesday evening by contending that the lawyer general's judgment broke with standard hone and included at slightest 2 blunders. The lawyer has not recorded any movement on take note, nor moved to settle the proposed judgment, Robert said within the recording. Her unrefined surge to memorialize a judgment abuses all acknowledged hone in unused York State Court. Citing the magnitude of the punishments within the case, Robert asked a remain of punishments by 30 days if Engoron picks to sign the lawyer general's proposed judgment. Given that the court-appointed screen proceeds to be input, there's no bias to the lawyer in briefly remaining authorization to permit for a deliberate post-judgment handle, especially given the size of judgment, Robert composed. In a brief letter to Engoron Thursday, state lawyer Andrew Amer contradicted the ask, contending that Robert fizzled to legitimize why an extra delay of 30 days would be vital and composing that Engoron's decision within the case cleared out no room for assist talk about approximately the judgment. Nor do litigants give any premise for remaining requirement of the judgment. Indeed, they asked such alleviation in their post-trial brief, which the court declined to give, Amer composed. Amer to question to alter proposed by Robert to move the address of 6 of Trump's businesses, which are respondents within the case, from unused York to Florida. At last, the court ought to dismiss defendants' endeavor to alter the trade address of 6 entity litigants to Florida, as the record builds up those substances are found in Trump Tower at 725 Fifth Avenue in modern York, the office building in which the administrators who carry out the business activities of those substances work, Amer composed. Trump was fined $354.8 million, plus roughly $100 million in pre-judgment intrigue final week, after Engoron determined that he expanded his net worth to induce more favorable advance terms.